Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibuyers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is Sunday, February 1st. Hope you guys have had a good weekend. We have been snowed in after a full day of a beautiful snow yesterday. It was just nice to get out and walk around, and I always love how quiet it is after it snows. But now I'm ready for it to be gone and for summer to get here. All right, so we're going to play a little catch up in a couple of the cases we've been following. Just a reminder, tomorrow at 10 a.m., the jury will be back to deliberating in the Brendan Banfield trial, and I will be running that feed live. For those of you that cannot watch, if you're subscribed and you have notifications enabled, when we do get a verdict, I will do a really quick YouTube short to let you guys know. And then I will do one after the verdict is read to let you know what it is. I know some people have to work and they can't necessarily sit and have a feed going for 8 hours if it takes that long. Hopefully not. But since I've been covering that trial, I really haven't had much time to catch up on other cases. Later this week, I'll also have part 2 of the Megan Trussell case out. But today, we are going to catch up in Kouri Richins and Michael McKee. Let's start with Kouri. Jury selection begins in 9 days. And don't forget, this is the first of 2 different trials. She'll stand trial at a later date for 2 counts of mortgage fraud, which is a second-degree felony, and 2 additional counts of forgery, which is a third-degree felony. She is asked again for the trial to be moved to Salt Lake City after receiving jury questionnaires. Now, she did try once, and that was denied. And then she tried to push it up to a higher court, but the Supreme Court declined to take up the case. So that new defense motion was filed just this past Friday. And it says, now that the court has the responses to the jury questionnaires, it is obvious that Ms. Richins does not have a reasonable likelihood of a fair trial in Summit County. A survey conducted last year showed 79% of Summit County residents recognized her case, and 49% have followed it either very or somewhat closely. They also added that the update figures now before the court are even higher. Of the 1,723 questionnaires that were returned, 1,472, or about 85.3% of people recognized her case. And among those respondents, 884, or roughly 60%, said they had followed it either somewhat or very closely. Now, this leaves 251 potential jurors who have not heard of the case, but the defense did say most of these jurors answered other questions in a way that would immediately strike them for cause. And then when those jurors are taken out of the equation, they're left with approximately 72 potential jurors. And within those 72 potential jurors, they feel that some may not remember the case right now, but they could once the facts start to come out at trial. Although there is no magic number as to how small a potential jury pool can be under Utah law, the jury pool must represent a fair cross-section of the community. So we'll see what the judge rules on that. I really think this close to trial, it's probably not going to be moved, but crazier things have happened. We're going to move on to the state's opposition to the defendant's motion to compel witness disclosure of communications with trial witnesses and also a motion for sanctions. I read the defense motion on a prior episode, so I'll link that in the description in case you missed it. But essentially, they're accusing the state of harassing witnesses. So let's read the response by the state. The state's preferred disposition and grounds. The state of Utah requests the court deny the defendant's motion to compel disclosure of communications with trial witnesses. The state reviewed its Giglio investigators' witnesses' communications consistent with its Giglio obligations, and as a result made 5 disclosures involving a single detective and a single witness. The state did not identify any additional material that must be disclosed under Giglio. So what's Giglio? They're talking about evidence the defense has a right to know because it could be used to impeach a witness. Once again, defense counsel misrepresents to the court and the public what the prosecution has said, this time 2 weeks before jury selection. Sanction is thus appropriate. The next section is the statement of relevant facts. Contrary to the motion, the lead prosecutor did not respond to defense counsel's concern over Detective Jeff O'Driscoll's text messages to the state's witness, Anna Isbell. I do not think O'Driscoll acted improperly. Quite the opposite. The lead prosecutor responded, quote, I get it. I don't like the look of the text at all, and I and Detective O'Driscoll discussed that, end quote. Contrary to the defendant's objection to state's motion to seal and request to remove private classification from Exhibits A and B, the lead prosecutor's response does not require interpretation, and interpreting the statement to mean, quote, I do not think O'Driscoll acted improperly, end quote, is perverse. During the meet and confer, the lead prosecutor explained that when Detective O'Driscoll and his partner went to knock on Miss Isbell's door to see if she would speak, she had put her aggressive dog out, and that Detective O'Driscoll sent the text immediately afterward. Defense counsel said she would put O'Driscoll's version in her motion. She did not. Defense counsel also said she would get it right in the motion and not be overly dramatic. She did neither. Contrary to the motion, Detective O'Driscoll did not threaten to get a warrant for Miss Isbell's arrest and to bring a pole for her dog if she did not come in for an interview. Rather, the text explains what could happen if Miss Isbell did not appear at trial. During the meet and confer, the lead prosecutor told defense counsel, quote, I think your view of Detective O'Driscoll is inaccurate and biased, end quote. The defense counsel acknowledged, quote, probably, end quote. The state raising defense counsel's misinterpretation of the text message, it's a matter of fact. Contrary to the motion, the lead prosecutor did not decline to make additional disclosures of all communications between O'Driscoll and the trial witness. Defense counsel never asked for that. Instead, she informed the prosecutor she would ask the court. Defense counsel addressed only O'Driscoll's texts and did not raise communications involving investigator Travis Hopper or the broader relief requested. Defense counsel acknowledged filing the motion partly for the public's review and to encourage reporting of similar communications. The state argues this created potential jury pool contamination rather than focusing on limited witness questioning. The next section is the argument. The state again asserts it complied with Giglio obligations, made 5 disclosures, and located no further material. The motion, the state says, publicly maligns the prosecution shortly before jury selection by misrepresenting what the lead prosecutor said about Detective O'Driscoll. The filing cites Utah standards of professional and civil conduct, arguing defense counsel created an unjustified record and knowingly misstated facts. The state further argues that the objection's suggestion that jury exposure could be cured in voir dire fails because defense counsel's publicity itself created the problem. The state concludes the requested relief is unnecessary and sanctions are warranted instead. So their conclusion, the state asked the court to deny the motion and sanction defense counsel for material misrepresentations to the court and the public. I'm so ready for this trial to get started. We will live stream every day, and I'll be breaking it down for you twice a day in an hour or less. Moving on to Michael McKee, who is accused of murdering Spencer and Monique Tepe, Monique being his ex-wife. I've uploaded his booking video after his extradition back to Ohio, as well as his arraignment to the YouTube channel, and I will link both of those in the description. He's charged with 4 counts of aggravated murder and 1 count of aggravated burglary. And we're starting to learn more about Michael's movements leading up to the murders of Spencer and Monique. One thing that's been reported is that he used a silencer on that firearm when he allegedly shot and killed them. I do have the probable cause affidavit, so let's read through that. It says, on December 30th, 2025 at 9:57 a.m., Columbus Police Patrol officers were dispatched, and they give their address, on a check on the well-being of Dr. Spencer Tepe, who had not shown up for work. Officers arrived and found Dr. Tepe and his wife Monique Tepe deceased inside, suffering from gunshot wounds. 2 minor children were found inside the home unharmed. Columbus Fire Medic Number 7 responded and pronounced both victims deceased at 10:11 a.m. Columbus Police Homicide Unit Team 2 was advised, responded, and initiated an investigation. Early on in the investigation, detectives were advised by identifiable friends and family of Monique Tepe that Monique had told them her ex-husband, Dr. Michael D. McKee, had been abusive and had made numerous threats on her life during and after their marriage. An identifiable witness told detectives that Monique had shared an allegation against Michael of forced, unwanted sex and of strangulation. Another identifiable witness told detectives that Michael McKee had told Monique that he could kill her at any time and would find her and buy the house right next to her, that she will always be his wife. During the investigation, detectives were able to identify a suspect through neighborhood video surveillance. The suspect was tracked to a vehicle which arrived just prior to the homicides and left shortly after the homicides. Video of this vehicle and very distinct features allowed detectives to identify both a stolen Ohio license as well as an Arizona license being displayed on it at different times. I think they mean license plates, but they didn't put the plates part. Further searches showed this vehicle to be associated with the past address of Michael McKee, as well as his current work address in Rockford, Illinois. Additional video was obtained and showed McKee in possession of the vehicle prior to and after the homicides. Detectives also recovered video of the same suspect entering the curtilage of, and they list the address, on December 6, 2025, and exiting a few hours when the Tepes were away. So that's just about 3 weeks before the murders. They know he was there on their property. So what's a curtilage? It's essentially an extension of your property, but not the house. It could be your lawn, your driveway. In other words, he was on their property. These dates are consistent with video recovered of the silver SUV and are consistent with dates which Michael McKee was not on the schedule at St. Anthony's Hospital. On January 9th, 2026, detectives seized the silver SUV bearing the Arizona temporary tag from the lot at St. Anthony's Hospital, Rockford, Illinois, where Michael McKee works. Detectives noticed fresh scrape marks on the window where the sticker, which had been on the vehicle prior to the homicides, had been hastily removed. During the time of the homicides, Michael McKee's phone had been left at St. Anthony's Hospital in Rockford, Illinois, and showed no activity for approximately 17 hours from December 29th until after 12 p.m. on December 30th, 2025. Most recently, while Monique and Spencer were at the Big Ten championship game in Indiana on December 6th with several other couples, Monique went back to her hotel room early in the second half. When identifiable friends asked Spencer why Monique had left the game, he told them she was upset about something involving her ex-husband and was going back to the hotel. They didn't put this in here, but it's been reported that Spencer did go back to the hotel with Monique. So we don't know what prompted that, whether somebody tipped her off that he was there. However, police has said there was no police report filed, or was it maybe a text or a communication from Michael? That's something that will likely come out at a preliminary hearing or trial. I do believe the digital forensics is going to be huge in this case. We'll see how far back he was stalking her and what he was doing online regarding Monique and Spencer. Monique's brother-in-law responded to someone on Facebook and said he knew within the first hour it was Michael and not some robbery gone bad. He also said both kids had their own rooms and the family dog usually stayed in the 4-year-old's room. Spencer and Monique would keep all the doors closed, so it gave him hope neither child saw anything. So that's the latest on those two cases. Just wanted to play a little catch up while I'm stuck in the house, but that's it for today. We'll see you guys tomorrow morning, 10 a.m. for Verdict Watch in the Brendan Banfield trial. Hope you guys have a good rest of your afternoon. We will see you soon.